Counselor, what is subject matter jurisdiction?
Senator, subject matter jurisdiction refers to the ability of the courts to entertain matters. Cases that has to be presented in federal court have to be, can be moot, have to be ripe, parties have to be standing, and of course, federal courts can only see cases and controversies.
What is substantive due process?
Substantive due process is the process that is used when deciding the constitutionality of a statute, of a matter, distinct from procedural due process, which is based on the process that the courts follow when people are deprived of the due process of law, property.
I'm sorry. What's the difference between substantive due process and procedural due process?
It's the approach.
And how is the approach different?
It's different because one, the procedural due process refers to the procedure that it's followed, while the substantive due process technically refers to the way the constitutionality of a statute it's viewed. That's my understanding.
Judge, the middle judge, I'll call you. Can the United States Congress do anything, legislate in any area that the Constitution doesn't prohibit?
Thank you for your question, Senator.
You're welcome.
That would be correct. I believe it's under the 10th Amendment. There are certain discretion for Congress to go beyond the list that the Constitution provides in terms of the matters that can be legislated.
So you believe that Congress has plenary power as opposed to enumerated powers?
Well, I think that the Supreme Court has acknowledged that there are some rights and that are not enumerated, and the Constitution recognizes the Congress's ability to...
No, we're not talking about unenumerated rights. I'm talking about the power of Congress to legislate.
Congress indeed has that power as per constitutional acknowledgement, sir.
Okay. So you're telling me that Congress can legislate in any area unless someone can point to the Constitution that says it cannot?
My understanding would be that Congress indeed can legislate extensively. It doesn't have to be enumerated exclusively. I think that's a recognition that Constitution acknowledges.
I don't think that's right, Counselor or Judge. Judge?
Yes.
Can you tell me what the Chevron doctrine is?
Yes, the Chevron doctrine is a Supreme Court case in which the Supreme Court ruled that administrative agencies should be given a deference for the decisions that they make. And that decision was questioned somehow in the recent EPA Supreme Court case.
Okay, that's right. What's the holding in Obergefell, Judge?
For me?
I'm sorry.
Oh.
I'm sorry.
I'm sorry.
Start here and go back that way.
Okay.
Obergefell is the Supreme Court case that recognized same-sex marriage.
Did it hold that same-sex marriage is legal?
Well, it held that it is a protected constitutional right.
Yeah. See, that's not the way I read Obergefell. What I read Obergefell to say is that so long as the relationship is not incestuous, that you and I have the right to marry whoever we want to. And there's no reason to exclude people of the same sex. That's very different, is it not?
Well, Senator, I granted you what I believe that's the holding for that case. However, if I were to become a district judge and if I were to apply that case, I assure you that I will apply the holding of that case faithfully.
Counselor, let me jump down here. Can you tell me what, if you're on the federal district bench, you'll be asked on occasion to issue a universal injunction. Can you help me understand the legal basis, the authority of a federal district judge to issue a legal injunction or universal injunction?
Senator, let me start by saying that I have never worked with a universal injunction, nor the District of Puerto Rico has ever issued a universal injunction.
Yes, ma'am.
Having said that, there is a lot of debate as to
Yes, ma'am, but the
what's the
chairman's going to
source?
cut me off. Just tell me what the legal authority is for a federal district court judge to issue an injunction that affects beyond his or her judicial district.
As I said, I have never worked with a universal injunction. My understanding is that it comes from Rule 65 of the Rules of Civil Procedure, which are the rule that governs injunctions. That's my light understanding on the matter. As I've said, I have never worked with a universal injunction.
Okay, thanks, Mr. Chairman. Ms. Desai, am I saying your name right?
Senator, it's Desai.
Desai. You introduced your children, and I missed that part of your testimony. Are they here?
They are, Senator. My three daughters, one of them looks like she's asleep. She's probably not converted from Arizona time yet. They're 10, 7, and 5.
Okay. Kids, you can do a lot better than ice cream, okay? If you would like me to negotiate for you, I'll be happy to. Ms. Desai, Senator Durbin talked to you about a case on which you were counsel. Was that the case where plaintiffs sought to extend the voter registration period?
Yes, Senator.
Okay. This was a period of time set in statute by the legislature, as I recall, in which people in Arizona could vote.
Correct.
Right. And the plaintiffs wanted to extend that period of time.
Correct.
And they sued the Secretary of State.
Yes, Senator. Again, I wasn't involved at the trial court level, but if I remember correctly, the Secretary of State was a defendant. She might have been the only defendant, although I remember that the county recorders were involved at some point in that litigation.
Okay. And who was the Secretary of State then?
The Secretary of State at that time and currently in Arizona is Katie Hobbs.
And what party is she in?
She is a Democrat.
Okay. In that case, did you make the decisions, or did the Secretary of State make the decisions?
Senator, whenever I represent a client, I endeavor to make decisions with my client, and after advising my client fully of the options, take direction from my clients.
Yeah, it's the way it worked when I practiced law, too. The Secretary of State decided to settle the case and extend the time to register the vote. Is that the ultimate outcome of the case?
Senator, there was discussion about a settlement, but the settlement could not be, if I remember correctly, there was not enough time to enter into and finalize a settlement. So the ruling from the Ninth Circuit panel is the ruling that the parties ultimately implemented for purposes of determining the outcome of the voter registration deadline.
So the Secretary of State and the plaintiffs went to the Ninth Circuit and asked the Ninth Circuit to issue that ruling?
Senator, what happened in that case, to the best of my recollection, is that there was conversations with all of the parties, so the plaintiffs, the Secretary of State, as well as counsel for interveners, which were both presidential campaigns. I think also the
Yes, ma'am.
parties.
Excuse me for interrupting, but I'm going to run out of time, Counselor. My understanding is, and I think it's accurate, that the Secretary of State and the plaintiffs went to the Ninth Circuit and said, we have worked this out. We recommend that you rule this particular way. Isn't that what happened?
Senator, I think it was all of the parties.
Right, all of the parties.
Correct, including the interveners, which included the political parties and the campaigns for both presidential candidates.
So the Ninth Circuit ended up changing the state statute ultimately.
Senator, the order from the Ninth Circuit, I believe, was to reverse the district court's order extending the voter registration deadline, but allowing voters who had relied on that opinion or that order and registered to accept those voter registrations.
Right. Okay. All right. Well, I've got 13 seconds. Ms. Pryor, explain to me, Judge Pryor, excuse me, explain to me the legal basis for a universal injunction.
For a universal,
Universal injunction, the legal basis.
the legal standard for nationwide.
Not the standard, the legal basis. Where do the federal district judges get the power to issue a universal injunction that affects everybody in the United States?
I understand, Mr. Kennedy, that question as to whether or not judicial officers have extended and gone beyond their limited power under Article 3 is a highly debated question of both public debate and discussion.
Yes, ma'am, but when a federal district judge issues a universal injunction that applies not just in his or her district, judicial district, but the United States, and the parties say, Judge, what is your legal basis for doing this? Is there a statute? Is it in the Constitutional? What is the answer?
What within our district and the Southern District of Indiana, the injunction, the preliminary injunction, has been limited to that of the parties and the litigants.
Maybe I'm not being clear. I'm sorry, Mr. Chairman. Just, if you could, just tell me the legal basis. Where does a federal judge get the authority to issue a universal injunction?
The authority that judges in the DC Circuit or in other areas that have applied a nationwide injunction, the question that was raised before the court, or the legal standard they have used, is questioning whether or not the federal government, a policy or executive power can be executed. In those circumstances, those judges have issued what has been deemed as nationwide injunctions.
I know they have, but what's the legal basis for it?
Again, that's my understanding of when those have been enforced.
Okay. Thanks, Judge.
Thank you.
Senator Cruz.
Thank you, Mr. Chairman. Congratulations to each of the nominees. Ms. Desai, you have been a Democratic donor. You have been a partisan advocate for causes with which you believe. That includes legalizing potent strains of marijuana. That includes fighting against religious liberty accommodations. That includes being active in fighting against school choice in the state of Arizona. Now, as an American, you have a right to express your First Amendment rights. The job of a judge is different. So I guess my first question is, how do you view the job of a federal appellate judge as different from being a partisan advocate?
Thank you, Senator, for that question. I think the role of an advocate is starkly different than the role of a judge. As an advocate, you start with a position. You represent, you're duty-bound to zealously advocate and represent your client and their interests. As a
Well,
judge,
but let me focus in particular, like you've been very active in an organization that fights against school choice in Arizona, and that has not been, as I understand it, as a paid attorney. That is a passion project of yours. You and I disagree on that. I think school choice is the most important civil rights issue in this country. I'm not interested in a substantive debate on school choice right now. My question to you is, if you are a federal appellate judge, Arizona is one of the leading states in the country for school choice, for providing low-income children, many of them minority children, the opportunity for access to an excellent education. If you're confirmed as a judge, will you be able to take your personal policy and political hostility to school choice, will you be able to set that aside and follow the law?
Senator, I am committed to following the law objectively and without interjection of any of my own personal or political views in any case that is presented before me if I am so fortunate to be confirmed.
And that includes on the topic of school choice.
Senator, no matter what matter I have in front of me and no matter what my personal or political views may be, they will not play a role in any case or decision that comes before me if I'm so fortunate to be confirmed.
Okay, let's talk about another area of your advocacy. In a legal challenge to Arizona House Bill 2023, which prohibited ballot harvesting, you argued the bill not only had the incidental effect of lowering minority turnout, but that it was actually, quote, designed to suppress voting in minority communities. As you know, the Supreme Court 6-3 rejected that argument. Do you still believe that prohibitions on ballot harvesting are designed to suppress minority votes?
Thank you, Senator. The Supreme Court in Brnovich v. DNC set forth the guideposts for determining when a law violates Section 2 of the VRA. They've indicated the factors to look at include opportunity to vote, openness of voting.
Okay, I recognize and I'm aware what the Supreme Court has held, and so it rejected the argument. I'm asking you, do you believe, you wrote as an advocate, that prohibitions on ballot harvesting are designed to suppress minority votes? Do you believe that as a factual statement?
Senator, the statements that you're reading from were written in an amicus brief as an advocate, filing that on behalf of my clients. As a judge, I would apply unreservedly, fully, and faithfully the precedent set forth by the Supreme Court.
So that brief you filed on behalf of a group called Fair Fight Action, is that correct?
Senator, I had two clients in that for that amicus brief. It was Fair Fight Action and the Arizona Voter Empowerment Task Force.
So has Fair Fight Action ever disputed the integrity of an election?
Senator, I'm not aware. I haven't studied that. I don't know.
You don't know?
I don't know.
But who started Fair Fight Action?
My general understanding is that Fair Fight Action is an organization that was started by Stacey Abrams.
And Fair Fight Action disputed and litigated against the integrity of the election in Georgia in 2018. You're right, it was started by Stacey Abrams. And in fact, Fair Fight Action argued in court that the voting machines in Georgia actually switched votes from her to Brian Kemp. Is that correct?
Senator, my involvement with Fair Fight Action extends to filing that amicus brief in the Brnovich v. DNC case about the Arizona election laws. I was not involved with and I'm not familiar with Stacey Abrams' gubernatorial campaign from 2018. I believe Fair Fight Action was actually created after that election, but again,
but it was created to challenge that election. It was part of Stacey Abrams' ongoing efforts to maintain that she was in fact the governor of Georgia, notwithstanding the voters of Georgia disagreeing and voting for another candidate. Let me ask you, the last major bipartisan examination of voter fraud was chaired by Democratic President Jimmy Carter and Republican Secretary of State James Baker. The Carter-Baker Commission concluded that prohibitions on ballot harvesting protect election integrity because ballot harvesting invites voter fraud. Do you believe Democrat former President Jimmy Carter was actively trying to suppress minority votes, as you argued the provision in Arizona was doing?
Senator, thank you for that question. I'm not familiar with the facts that you recounted, but what I can tell you is that I would faithfully apply the rule of law from the Supreme Court and the Ninth Circuit precedents if I'm confronted with a case that challenged election laws.
Final question, because my time's expired. You wrote that brief without examining what the Carter-Baker Commission recommended? You made that allegation about ballot harvesting without even knowing what the Carter-Baker Commission said?
Senator, again, as I sit here today, I'm not familiar with those facts, but like I said, I am committed to the rule of law and to implementing the Supreme Court's precedent with respect to how to evaluate state laws that are relating to ballot collection or any other laws that are challenged under Section 2 of the VRA.
Thank you.